Gifting real estate to a family member can feel like a generous and practical decision. Many Minnesota homeowners consider transferring a home, cabin, or rental property to a child or loved one as part of their estate plan. But what many people don't realize is that gifting real estate can have significant tax consequences, both under federal law and Minnesota law. And those consequences are often very different from what people expect. Today, we're going to walk through the tax implications of gifting real estate in Minnesota so you can avoid costly mistakes and make informed decisions. Hi, my name is Alec Osland, and I'm an attorney at the Yanowitz law firm, where we've been assisting families with wills, trusts, and probate for over 30 years. Let's start with the basics. For tax purposes, a gift occurs when you transfer property and receive less than fair market value in return. This includes giving away real estate for free or selling it to a family member for less than it's worth. The IRS looks at the property's fair market value at the time of the transfer, not what you originally paid for it. The value is what drives most of the tax consequences. Now, many people worry about gift tax right away, so let's go ahead and clear that up. Minnesota does not have a state-level gift tax. Gift tax is strictly a federal issue. The good news is that most people will never actually pay federal gift tax. Each year, you can gift up to a certain amount per person without any reporting requirement. Right now, that is $19,000 for 2026. If the value of the real estate exceeds that annual exclusion of $19,000, you usually still don't owe tax immediately. Instead, the excess amount reduces your lifetime federal gift and estate tax exemption. However, and this is critical, you are still required to file a federal gift tax return and to report the transfer to the IRS. Even when no tax is owed, failing to file that return can cause serious problems later, especially when your estate is settled. But gift tax is not always the biggest issue. One of the most important and most overlooked tax consequences of gifting real estate involves capital gains tax. When you gift real estate during your lifetime, the person receiving the property generally takes over your original cost basis. This means they inherit your tax history with the property. For example, if you bought a Minnesota home or cabin years ago for, let's say, $200,000 and it's now worth $700,000, your child's basis is still that original $200,000. If they later sell the property, they could owe capital gains tax on that very large amount. This is very different from what happens when that property is inherited after death. In most cases, inherited property receives what we call a stepped up in basis to the fair market value as of the date of death. That stepped up can dramatically reduce or even eliminate capital gains tax when the property is sold. Because of this, gifting real estate during your lifetime can sometimes create a much larger tax burden for your children than passing the property through an estate plan. Now, let's talk about Minnesota estate taxes. Minnesota has its own estate tax, with an exemption that is significantly lower than the federal exemption. So in 2026, the federal exemption is $15 million, and Minnesota has an exemption of $3 million. While gifting can reduce the size of your taxable estate, Minnesota does not always treat lifetime gifts in the same way people expect. Improper gifting strategies can fail to produce the intended tax savings and may still leave your estate exposed to Minnesota estate tax, while creating capital gains issues for your heirs. There are also property tax considerations. In Minnesota, gifting real estate can affect homestead status if the transfer isn't structured correctly. Losing homestead classification can result in higher property taxes and loss of valuable tax benefits. Rural land may also lose favorable classifications like green acres or rural preserve if ownership changes are mishandled. And once you gift property, it's no longer yours. That can impact long-term care planning, Medicaid eligibility, and your financial security later in life. Gifting real estate within certain timeframes can create penalties or disqualifications from benefits. So what's the takeaway? In Minnesota, gifting real estate isn't just a simple transfer. While it may feel like an easy way to help your family avoid probate, it can create unintended tax consequences, especially capital gains exposure, and complicate estate long-term care planning. In many cases, alternatives like transfer on death deeds, properly funded revocable living trusts, or other estate planning strategies can achieve your goals more effectively while preserving tax benefits and protecting your family. The right approach depends on your financial situation, the type of property involved, and your long-term goals. At the Yanowitz Law Firm, we help Minnesota clients evaluate whether gifting real estate makes sense or whether there's a better option that avoids unnecessary taxes and risk. If you're considering gifting real estate in Minnesota, we encourage you to speak with an experienced estate planning attorney before making any transfers. Thank you for watching, and make sure to subscribe to our YouTube channel to find out when we post more videos about estate planning and tax guidance from the Yanowitz Law Firm. Thanks. Have a great day. Bye.